The following is a reading of the George Santos Superseding Indictment, which was released on October 10, 2023. The text has been edited for clarity, ease of listening, and length. This recording was produced using text-to-speech software. Superseding Indictment, United States District Court, Eastern District of New York, United States of America against George Anthony DeVolder Santos, also known as George Santos, defendant. Relevant individuals and entities. 1. The defendant. George Anthony DeVolder Santos, also known as George Santos, was a resident of Queens and Suffolk counties. During the 2020 and 2022 election cycles, DeVolder Santos campaigned as a candidate for the United States House of Representatives. On or about November 8, 2022, DeVolder Santos was elected the United States Representative for New York's 3rd Congressional District, which covered parts of Queens and Nassau counties in the Eastern District of New York. DeVolder Santos was sworn into office on or about January 7, 2023. 2. DeVolder Santos for Congress, or the Committee, was the defendant's principal congressional campaign committee. 3. Nancy Marks was the treasurer of the committee. Marks provided additional services to the committee through a political consulting company that she operated and which was located in Suffolk County, New York. 4. National Party Committee Number 1, an entity the identity of which is known to the grand jury, was a National Party Committee headquartered in Washington, D.C. National Party Committee Number 1 managed a program pursuant to which National Party Committee Number 2 provided financial and logistical support for congressional candidates who qualified for the program. The program had 3 phases, each with its own qualifying criteria. To qualify for the second phase of the program, congressional candidates were required, among other things, to demonstrate that their campaign committee had raised at least $250,000 from third-party contributors in a single quarter. 5. The DeVolder Organization, LLC, was a Florida limited liability company formed on or about May 11, 2021. With its principal place of business in Melbourne, Florida, the defendant was the sole beneficial owner of the DeVolder Organization, LLC. 6. Company Number 1, an entity the identity of which is known to the grand jury, was a Florida LLC formed on or about November 1, 2021, with its principal place of business in Merritt Island, Florida. At the time of its organization, Company Number 1 had 2 authorized managers, one of which was the DeVolder Organization, LLC. 7. Person Number 1, an individual whose identity is known to the grand jury, was a political consultant operating in Queens County and surrounding areas, including areas within the Eastern District of New York. In or about and between September 2022 and October 2022, at the direction of the defendant, Person Number 1 acted on behalf of Company Number 1. 8. Investment Firm Number 1, an entity the identity of which is known to the grand jury, was a Nevada corporation with its principal place of business in Melbourne, Florida. Investment Firm Number 1 was purportedly engaged in retail sales of securities products. In or about and between January 2020 and March 31, 2021, the defendant was employed by Investment Firm Number 1 as a regional director. In that capacity, Santos received an annual salary of approximately $120,000, which was deposited into a personal bank account maintained by Santos in regular intervals beginning on or about February 3, 2020, and continuing through on or about April 15, 2021. The defendant's campaign-related fraudulent schemes. During the 2022 election cycle, the defendant devised and executed at least 3 fraudulent schemes to obtain money for himself and for the committee, by making various material misrepresentations and omissions to, among others, the FEC, National Party Committee Number 1, potential contributors to the committee and the public. First, in or about and between December 2021 and November 2022, the defendant and Nancy Marks devised and executed a scheme to submit materially false reports to the FEC on behalf of the committee, in which they fraudulently inflated the committee's fundraising numbers. The purpose of the scheme was to qualify DeVolder Santos for different phases of the program and thereby receive financial and logistical support from National Party Committee Number 1. As part of the party program scheme, DeVolder Santos and Marks agreed to falsely report to the FEC that family members of DeVolder Santos and Marks had made significant financial contributions to the committee, when DeVolder Santos and Marks both knew that these individuals had not made the reported contributions. Further, as part of the party program scheme, DeVolder Santos and Marks agreed to falsely report to the FEC that DeVolder Santos had loaned the committee significant sums of money, when DeVolder Santos had not made the reported loans and, in fact, did not have the funds necessary to make such loans at the time. Second, in or about and between December 2021 and August 2022, the defendant devised and executed a fraudulent scheme whereby he stole personal identity and financial information of individuals who had contributed to the committee and used it to cause these individuals' credit cards to be charged repeatedly without authorization. Through these unauthorized transactions, DeVolder Santos transferred funds to the committee, to the campaigns of other candidates for elected office, and to his personal bank account. Further, for the purpose of concealing the true source of funds and circumventing campaign contribution limits, DeVolder Santos falsely represented that the political contributions were made by other individuals, such as DeVolder Santos's relatives and associates. Third, in or about and between September and October 2022, the defendant devised and executed a scheme to defraud and to obtain money from supporters of his candidacy Congress by fraudulently inducing them to contribute funds to Company Number 1 under the false pretense that the money would be used to support DeVolder Santos's candidacy. In truth, DeVolder Santos spent thousands of dollars of the solicited funds on personal expenses, including luxury designer clothing and credit card payments. DeVolder Santos personally and through person number 1 communicated false information about Company Number 1 to those supporters, including that Company Number 1 was a Section 501c4 social welfare organization or an independent expenditure-only committee, and that contributions made to Company Number 1 would be used on independent expenditures in support of DeVolder Santos's candidacy during the 2022 election cycle. In actuality, upon receipt of contributions by those supporters to Company Number 1, DeVolder Santos converted much of those funds to his own personal benefit. The party program scheme. Throughout 2021, the defendant and Nancy Marks sought for the committee to report fundraising totals sufficient to meet the $250,000 threshold necessary to qualify for the second phase of the program. For example, on or about April 1, 2021, Marks emailed the defendant, George Anthony DeVolder Santos, and other agents of the committee, stating, quote, "Our goal is to go higher each quarter, so as everyone is aware, it is to make the program. For the third quarter of 2021, the committee failed to qualify for the program due, in part, to its failure to report $250,000 in contributions from third-party contributors in the quarter." On or about October 12, 2021, the defendant sent a text message to agents of the committee, including Nancy Marks, asking an agent to, quote, "check in with" an employee of National Party Committee Number 1 to determine why the committee failed to qualify for the program. An agent of the committee responded to DeVolder Santos that, quote, "The only driver that matters is raising $250,000, not loans or candidate contributions, in a single quarter, and it's really that simple, though. We haven't done that yet, and that should be our focus." DeVolder Santos replied, quote, "We are going to do this a little different. I got it." Fraudulent Year-End 2021. Report. In or about and between December 2021 and January 2022, the defendant and Nancy Marks conspired and agreed to falsely inflate the committee's fundraising totals, including but not limited to in public filings with the FEC, in order to mislead the FEC, National Party Committee Number 1 and the public, so that DeVolder Santos would qualify for the program and receive financial and logistical support from National Party Committee Number 1. In furtherance of that scheme to defraud, on or about December 18, 2021, the defendant texted Nancy Marks a list of the names of family members of George Santos and Marks, along with purported contribution amounts for each corresponding family member, for Marks to enter into the year-end 2021 report to the FEC for the purpose of ensuring that the committee appeared to reach the $250,000 threshold necessary to qualify for the second phase of the program. Contrary to the representations made by George Santos, none of the family members of George Santos and Marks had made, or ever did make, the listed contributions. George Santos also texted Marks, quote, "These are the donations we spoke about last night before we went to sleep. Total of $55,100. Let's talk Monday in person." On or about December 21, 2021, after Nancy Marks texted the defendant seeking the, quote, "list of donors, your family," George Santos again texted Marks the names and purported contribution amounts. This time, George Santos also included addresses and occupations for his relatives, information that George Santos knew would be required for the year-end 2021 report to the FEC. That same day, Marks emailed herself the content of this text message. On or about January 2022, the defendant repeatedly texted Nancy Marks about ensuring that the committee reached the $250,000 threshold necessary to qualify for the second phase of the program. George Santos advised Marks that he, quote, "really would like to know the final numbers for the quarter." On or about January 31, 2022, George Santos asked Marks, quote, "What did we figure out about the report?" and expressed that he was, quote, "lost and desperate." On or about January 31, 2022, the committee submitted the year-end 2021 report to the FEC, with Nancy Marks certifying that she had, quote, "examined this report, and to the best of my knowledge and belief it is true, correct, and complete." The year-end 2021 report further falsely reported a contribution of $2,900 from another family member of Nancy Marks, contributor number 11, an individual whose identity is known to the grand jury. These falsely reported contributions contained in the year-end 2021 report to the FEC totaled $53,200, causing the committee to falsely claim total quarterly receipts of $251,549.68, and thereby surpass the $250,000 threshold necessary to qualify for the second phase of the program. The defendant and Marks knew that none of these reported contributions were true. The defendant qualifies for the second phase of the program. Following the submission of the fraudulent year-end 2021 report to the FEC on or about February 10, 2022, the defendant signed an application for the program and caused it to be submitted to National Party Committee Number 1. The application noted that candidates accepted into the program would be eligible for additional campaign financial support, such as hybrid ads, coordinated expenditures, focus groups, splitting the cost of polling, etc. George Santos also submitted a biography falsely asserting, among other things, that he had worked for several prominent Wall Street financial institutions. On or about February 23, 2022, the defendant texted Nancy Marks, quote, "I got the program," based in part on its belief that the committee had exceeded the quarterly fundraising benchmark. National Party Committee announced the defendant as a candidate in the second phase of the program on or about February 25, 2022. Fraudulent, April 2022, quarterly report. In or about and between March and April 2022, the defendant and Nancy Marks continued their efforts to falsely inflate the committee's fundraising totals. George Santos and Marks agreed to falsely represent in presentations and communications with National Party Committee Number 1 and in a quarterly submission to the FEC that George Santos had loaned the committee $500,000, when in fact he had not. In approximately March 2022, the defendant continued to express concern with ensuring that the committee reported favorable fundraising totals in the first quarter of 2022. For example, on or about March 7, 2022, the defendant texted an associate, quote, "I have my back against the wall this quarter, LOL." Similarly, on or about March 15, 2022, the defendant texted another associate about the importance of the committee reporting substantial fundraising totals for the purpose of ensuring he qualified for the program and would receive the expected financial support from National Party Committee Number 1, stating, quote, "I have a very important meeting at the end of this week with National Party Committee Number 1. This meeting will decide if they will invest in my race, and so we need to come in with very strong fundraising numbers. There are several $1 million on the line with this, and having your name as a contributor to my campaign would be a very great help." On or about March 21, 2022, the defendant caused agents of the committee to deliver a Path to Victory presentation to National Party Committee Number 1, which falsely represented to staff members that George Santos was loaning the committee $500,000 during the first quarter of 2022. Further, the presentation listed as a key factor George Santos's, quote, "personal and political capital that will allow for a fully funded operation." When agents of the committee inquired, the defendant falsely represented that he was, in fact, making the purported $500,000 loan to the committee. For example, on or about March 30, 2022, an agent of the committee texted George Santos, quote, "Did you get the wire done for the Q1 loan?" George Santos responded, quote, "That's getting done tomorrow and it's not a wire, banker check." However, George Santos did not provide the committee with a check for the purported $500,000 loan, nor did he wire transfer such funds at that time. Moreover, at that time, George Santos did not have the funds to cover such a loan. In truth, George Santos had less than $8,000 in his personal and business bank accounts. On or about April 13, 2022, the committee further publicized inaccurate fundraising totals for the committee for the first quarter of 2022, relying on the false representation by the defendant that he had loaned the committee $500,000. Specifically, the committee issued a press release in which it stated that the committee would, quote, "report roughly $800,000 raised in Q1, a significant sum in what is likely to be one of the most expensive races in the country." This statement of the fundraising totals of the committee included the non-existent $500,000 loan purportedly made by George Santos. The press release further reported that George Santos had qualified for the second phase of the program by National Party Committee Number 1, quote, "a sign of the party's growing interest and belief in the competitiveness of this seat." On or about April 15, 2022, the committee submitted the April 2022 quarterly report to the FEC, which falsely reported that George Santos had loaned the committee $500,000 on March 31, 2022. George Santos and Nancy Marks did so for the purpose of making the committee appear more financially sound than it was, knowing that the FEC, National Party Committee Number 1, and the public would rely on the truth and accuracy of these reports. National Party Committee Number 1 provides financial support to the committee, based in part on the misrepresentations made by the defendant and Nancy Marks about the financial position of the committee in its reports to the FEC, presentations to National Party Committee Number 1, and public statements. National Party Committee Number 1 announced that George Santos had qualified for the third and final phase of the program on or about June 14, 2022. As a result of the defendant George Anthony George Santos's qualification for the third and final phase of the program, National Party Committee Number 1 provided financial and logistical support to the committee. For example, on or about September 27, 2022, National Party Committee Number 1 and the committee agreed to split the cost of a political poll. Financial assistance that the defendant knew to be a benefit derived from his qualification for the third and final phase the program. Similarly, qualification for the third and final phase of the program entitled the defendant to participate in joint fundraising committees with other qualified members of the program. On or about September 28, 2022, the committee and another political committee affiliated with George Santos received wire transfers from a joint fundraising committee for qualified members of the program. On or about October 18, 2022, the committee and another political committee affiliated with DeVolder Santos received a second round of wire transfers from a joint fundraising committee for qualified members of the program. The credit card fraud scheme. As part of the credit card fraud scheme, the defendant obtained the personal identity and financial information of individuals who had contributed to the committee and then caused their access devices to be charged repeatedly without authorization for DeVolder Santos's direct and indirect benefit, oftentimes concealing the true source of the funds by misappropriating the personal identity information of relatives and associates of DeVolder Santos without their authorization. For example, on or about December 14, 2021, contributor number 12, an individual whose identity is known to the grand jury, texted the defendant and another agent of the committee, providing billing information for 2 credit cards belonging to contributor number 12 for the purpose of authorizing a contribution to the committee. Thereafter, on or about December 17, 2021, DeVolder Santos caused a $5,800 contribution to be made to the committee using the credit card billing information provided by contributor number 12. That same day, DeVolder Santos caused 2 other contributions to be made to the committee or affiliated political committees using the credit card billing information provided by contributor number 12. As a result, DeVolder Santos caused approximately $15,800 in campaign contributions to the committee or affiliated political committees to be charged to the credit cards of contributor number 12 on or about December 17, 2021. This total exceeded the limit set by the Election Act for the 2022 election cycle for individual contributions to candidate committees. Contributor number 12 did not know of or authorize charges exceeding such limits. For the purpose of masking the true source of some of these funds, and thereby circumventing the Election Act's limits on the amount and sources of money that could be contributed to a federal candidate for elected office, DeVolder Santos falsely identified the source of the funds for one of these unauthorized charges to be a relative of DeVolder Santos, person number 2, an individual whose identity is known to the grand jury. As a result of DeVolder Santos's fraudulent deception, the committee submitted the year-end 2021 report to the FEC on or about January 31, 2022, which falsely identified person number 2 as the source of the funds for a $2,400 contribution and a $2,600 contribution, both made on December 17, 2021. In the following months, without the knowledge or authorization of contributor number 12, the defendant repeatedly used the credit card billing information of contributor number 12 in attempts to make at least $44,800 in unauthorized charges. DeVolder Santos attempted to use the credit card billing information of contributor number 12 to make contributions to the committee and to the campaign committees of other candidates for elected office. DeVolder Santos used the credit card billing information for contributor number 12 to transfer more than $11,000 to DeVolder Santos's personal bank account, again without the knowledge or authorization of contributor number 12. On or about August 1, 2022, DeVolder Santos used the credit card billing information for contributor number 12 to cause a charge of $12,000 using the credit card processing account of company number 1. Of that sum, approximately $11,651 was transferred to the bank account of company number 1. That same day, approximately $11,580 was then transferred from the bank account of company number 1 to the personal bank account of DeVolder Santos. In addition to contributor number 12, DeVolder Santos used the credit card billing information of other individuals to contribute to the committee and to the campaigns of other candidates for elected office, all without the knowledge or authorization of the individual cardholders. Again, in an effort to mask the true source of the funds and to circumvent the Election Act's limits on individual contributions, DeVolder Santos repeatedly masked those fraudulent transactions by using the names of other unwitting individuals, including individuals who had previously contributed to his campaign and his own relatives, among others. The Company Number 1 Fraud Scheme. As part of the Company Number 1 fraud scheme, The defendant directed person number 1 to solicit contributions to company number 1 from prospective contributors via emails, text messages, and telephone calls. In furtherance of those efforts, DeVolder Santos arranged for the creation of an email address associated with company number 1 for person number 1, provided person number 1 with the names and contact information of prospective contributors, and conveyed false information to person number 1 about the nature of company number 1 and the purpose of the contributions, knowing that person number 1 would then communicate the false information to prospective contributors. At the direction of the defendant, person number 1 falsely advised prospective contributors, inter alia, that company number 1 was a Section 501c4 social welfare organization or an independent expenditure-only committee and therefore not subject to contribution limits, and that contributions to company number 1 would be spent on television advertisements and other independent expenditures benefiting DeVolder Santos's candidacy for the House. At the direction of DeVolder Santos, person number 1 also provided prospective contributors with instructions for wiring funds to a bank account maintained by company number 1, as to which DeVolder Santos was an authorized signatory. It was further a part of the scheme to defraud that the defendant sent to prospective contributors one or more text messages in which he requested that those prospective contributors speak with representatives of company number 1, indicated that he needed contributions to company number 1, and falsely represented that such contributions would be spent on television advertisements independently purchased by company number 1 in support of DeVolder Santos's candidacy for the House. After receiving emails and text messages from the defendant and person number 1, and in reliance upon the materially false statements therein, one or more individuals made contributions to company number 1 in sums exceeding the limits pertaining to candidate committees. On or about September 12, 2022, the defendant falsely advised person number 1 via text message that company number 1 was, quote, a small C4 that existed just to help this race and that there were no limits with respect to contributions. DeVolder Santos knew that company number 1 was not, in fact, a social welfare organization. On or about October 4, 2022, person number 1, acting at the direction of the defendant and on behalf of company number 1, sent an email to contributor number 13, an individual whose identity is known to the grand jury. That email falsely stated, inter alia, that company number 1 was attempting to, quote, raise another $700,000 to reach our goal of $1.5 million to invest in DeVolder Santos's race, to compete with the money independently raised for DeVolder Santos's opponent. Thereafter, on or about October 20, 2022, person number 1, again acting at the direction of DeVolder Santos, and on behalf of company number 1, sent to contributor number 13 another email, which falsely stated that a contribution from contributor number 13 would be spent, at least in part, quote, to get our advertising up on TV. On or about October 25, 2022, person number 1, again acting at the direction of DeVolder Santos, and on behalf of company number 1, sent to contributor number 13 a text message, which again falsely stated that a contribution from contributor number 13 would be spent, at least in part, to purchase ads supporting George Santos. On or about October 26, 2022, in reliance upon these emails and text message, contributor number 13 caused the sum of $25,000 to be wired to company number 1. In addition, on or about October 12, 2022, person number 1, acting at the direction of the defendant George, and on behalf of company number 1, sent an email to contributor number 14, an individual whose identity is known to the grand jury. That email falsely stated, inter alia, that company number 1 was formed exclusively to aid in electing DeVolder Santos, and that, quote, there are no limits for contributors as we are a 501c4 independent expenditure committee under federal campaign finance law and do not coordinate directly with the Santos campaign. The email to contributor number 14 further stated that all funds raised by company number 1 would be spent, quote, directly on supporting George and his election. Further, The email to contributor number 14 contained an attachment, which DeVolder Santos had previously approved. That attachment described company number 1 as having been, quote, created for this singular purpose, to support that candidate, George Santos, and represented that company number 1 was, quote, fully committed to dedicating all its resources to making sure that George Santos is the next member of Congress representing New York's 3rd District. On or about October 21, 2022, DeVolder Santos sent to contributor number 14 one or more text messages in which DeVolder Santos reiterated the need for contributions to company number 1, which he falsely stated would be spent on TV advertisements. That same day, in reliance upon the email and accompanying text messages, contributor number 14 caused the sum of $25,000 to be wired to company number 1. DeVolder Santos knew that company number 1 was not, in fact, registered with the FEC as an independent expenditure-only committee or super PAC. Shortly after the contributions from contributor number 13 and contributor number 14 were received by company number 1 in the company number 1 bank account, they were transferred into bank accounts controlled by the defendant, including the DeVolder Santos bank account number 1 and a second personal bank account maintained by DeVolder Santos. From there, the funds received from contributor number 13 and contributor number 14 were spent by DeVolder Santos for his personal benefit, including to make cash withdrawals, personal purchases of luxury designer clothing, credit card payments, a car payment, payments on personal debts, and one or more bank transfers to DeVolder Santos's personal associates. Thus, contrary to representations made by DeVolder Santos and person number 1, who was acting at the direction of DeVolder Santos, these contributions to company number 1 were not spent on television advertisements or other independent expenditures in support of DeVolder Santos's candidacy for the House. The defendant's employment-related fraudulent schemes. On or about March 27, 2020, the Coronavirus Aid, Relief, and Economic Security, or CARES Act, was enacted. In light of the ongoing health crisis related to COVID-19, the CARES Act allocated additional unemployment benefits for eligible individuals. Specifically, the CARES Act established additional unemployment insurance programs, including the Pandemic Unemployment Assistance Program and the Federal Pandemic Unemployment Compensation Program. Both programs were federally funded and were administered by states, including New York State. Funds from both programs, as well as from the Federal Emergency Management Agency's Lost Wages Assistance Program, comprised the benefits fraudulently obtained by the defendant in connection with the scheme outlined below. On or about June 17, 2020, the defendant applied to receive unemployment insurance benefits through the New York State Department of Labor. In that application, DeVolder Santos falsely claimed to have been unemployed since the week of March 22, 2020. Beginning on or about June 19, 2020, and continuing through on or about April 15, 2021, DeVolder Santos certified his continuing eligibility for unemployment benefits on a weekly basis, in each case falsely attesting, inter alia, that he was unemployed, available to take on new work, and eligible for benefits. In truth and in fact. However, beginning on or about February 3, 2020, and continuing through on or about April 15, 2021, DeVolder Santos was a regional director at investment firm number 1. During that period, with the exception of approximately July 5, 2020 through August 30, 2020, DeVolder Santos received regular deposits into his personal bank accounts as part his regional director salary of approximately $120,000 per year. For the period of approximately March 22, 2020 through April 15, 2021, based on a false application and false weekly certifications to the New York Department of Labor, the defendant received approximately $24,744 in unemployment insurance benefits, which were deposited into DeVolder Santos bank account number 2. The benefits received by DeVolder Santos were fully funded by the United States and a department and agency thereof, to wit, The United States Department of the Treasury. False statements in House disclosure reports. Pursuant to the Ethics in Government Act of 1978, as a candidate for the House in 2020 and 2022, the defendant had a legal duty to file a financial disclosure statement at designated times prior to each of the general elections held on November 3, 2020 and November 8, 2022, respectively. In each of those House disclosures, George Santos was required to make a full and complete statement, disclosing, inter alia, a. his assets and income, transactions, liabilities, positions held, and arrangements and agreements. B. the source, type, and amount or value of income from any source other than from current employment by the United States government. And C. the source, date, and amount of honoraria from any source received for the year of filing and the preceding calendar year. As a candidate, George Santos was personally required to certify the House disclosures were, quote, true, complete, and correct to the best of my knowledge and belief. The Instruction Guide for Financial Disclosure Statements, published by the U.S. House of Representatives Committee on Ethics, provided that there were civil and criminal penalties for knowingly and willfully falsifying a financial disclosure statement. The defendant was required to make these House disclosures via an online filing system maintained by the House Committee on Ethics or pre-printed form, and to certify that the statements made therein were true, complete, and correct. George Santos was required to file the House disclosures with the Clerk of the House for transmission to the House Committee on Ethics. On or about May 11, 2020, in connection with the 2020 election for the House, the defendant filed 2 House disclosures in which he falsely certified that, during the reporting period, a. his only earned income consisted of salary, commission, and bonuses totaling $55,000 from Company Number 2, an entity the identity of which is known to the grand jury, and b. the only compensation exceeding $5,000 he received from a single source in which he had an ownership interest was an unspecified commission bonus from Company Number 2. Contrary to these attestations, however, as the defendant then and there well knew and believed, from approximately February 1, 2020 through the date upon which he filed the 2020 House disclosures, George Santos received approximately $25,403 in income from investment firm Number 1, which he failed to truthfully report as required. Further, George Santos knew that he had received only $27,555 in compensation from Company Number 2 in 2019. Thereafter, on or about September 6, 2022, in connection with the 2022 election for the House, the defendant filed a House disclosure in which he falsely certified that during the reporting period, a. his earned income consisted of $750,000 in salary from the George Organization, LLC. B. his unearned income included dividends from the George Organization, LLC valued at between $1 million and $5 million. C. he had no compensation exceeding $5,000 from a single source in which he had an ownership interest. D. he owned a checking account with deposits totaling between $100,001 and $250,000. And E. he owned a savings account with deposits totaling between $1 million and $5 million. Contrary to these attestations, as the defendant then and there well knew and believed, during the applicable reporting period, he had not received from the George Organization, LLC, the reported amounts of salary or dividends, and, during the reporting period, he did not maintain checking or savings accounts with deposits in the reported amounts. In addition, from approximately January 2021 through September 2021, George Santos received approximately $28,107 in income from investment firm Number 1 and approximately $20,304 in unemployment insurance benefits from the New York Department of Labor, both of which he failed to truthfully report as required. In the original legal document, the details of the counts being charged are included here. As the offenses have already been described above, they are being omitted. For more coverage of the George Santos affair, be sure to go to thebulwark.com. Thank you for listening.